going to talk about negotiation ethics in the context of intellectual property practice. So there are some questions. I think ethics in negotiation, I'm delighted that there was as much interest in this program as there is. It can be kind of a challenging subject, though, in many respects. One issue is that I think we traditionally think about negotiating from a position of strength and not sharing information. And so under one theory, we might say that these kinds of selective disclosures that we make to the other side, perhaps answers that are arguably misleading, aren't those sort of an accepted practice of negotiation and arguably even necessary? A second question concerns whether good faith is required when in the conduct of negotiations. Is honesty really the best policy? I mean, these are things that I think that folks in the audience could have vigorous and heartfelt debates about when it comes to negotiation ethics. And indeed, a review of the literature reveals those kinds of debates. Some would argue even that the ethics rules actually require an aggressive approach. So there are various theories about this. What I'm here to do today is to really having trouble advancing the slides. Okay. So we have some guiding factors that we have to take into account whenever we do negotiations. We have to, of course, be mindful of our client's instructions. We have to be aware of the significance of the matter to the client, what tactics the other side might be employing or might be anticipated to employ, to what extent is the client planning to participate in the negotiation, and obviously the party's relationship over time, the attorney's personal style. All of these things are important, but the ethics rules are always important when we're practicing law. Let me say in that regard that this program has been approved, as many of you know, for New York CLE, and in order to verify participation on the part of our CLE participants, I will be at 2 points during the program reading authentication codes to you. If you registered for CLE credit, you've received instructions regarding what to do with those codes. But it's certainly the case that you're going to want to note those codes when we reach those points in the program, perhaps about 20 minutes from now, and then again at around 1 o'clock. And I would also ask you, while I'm taking a moment to do some administrative announcements, and again, I apologize for our challenges in getting started here. It's certainly not the smooth start that we'd all hoped for, so we're sorry about that. But we're going to ask that you hold questions till the end. Chances are I might have anticipated your question and dealt with it, and it's just smoother, particularly given the technical difficulties that we're having to hold those questions. But feel free to submit them as we go, and we'll try to leave ample time for questions. I think we're certainly going to continue past 1 o'clock. Okay. So the ethics rules, as sort of some background, themselves make negotiation ethics a challenging subject, in that they arguably deliver to practitioners mixed messages. On the one hand, and these appear in various places throughout these rules, the messages, the preamble to the American Bar Association model rules, the text of the rules themselves, the commentary of the rules. These messages permeate in one place or another the messages that we get from the model rules. Let me just interrupt myself again to point out that my talk is based on the ABA model rules of professional conduct. Those are the basis for the ethics rules in almost every state now in the Union, including the state of New York. However, the rules have been adopted by those states, as you all know, to greater or lesser degrees. And in fact, while I will make a few comments that are New York specific as we go through, I cannot stress enough that the most important point about this presentation is that state ethics versions of the rules that I'll be talking about vary significantly. As compared with some of the other ethics topics that I've spent time working on over the course of my career, I was surprised when I started to work on negotiation ethics, the extent to which the applicable ethics rules vary. So I will be speaking primarily about the ABA model rules, but you should most certainly consult the rules that apply in the jurisdiction that you're practicing in, as well, of course, as the jurisdictions that you're admitted in. We'll talk a little bit about multi-jurisdictional practice at the end of the program, but to a surprising degree, the ethics rules is adopted in various states, in particular the ones that I'll be talking about today vary, and I'll highlight some of those differences as we go through. So back to the lawyer's duties, we get these mixed messages. On the one hand, we're told to strive for justice. On the other hand, we're told to zealously serve our clients. We are told to be honest, but zealous advocates. And we are told, of course, to preserve our client confidences, but of course, we're not allowed to assist a fraud. So these arguably mixed messages are what makes the application of the ethics rules challenging. So let's see how you do on a test of your legal ethics with regard to negotiation ethics. Starting out with question 1, a lawyer may not represent both the licensor and the licensee in a licensing transaction. Is that true or false? So proceeding through the analysis, back to some conflicts basics. I cite 2 schools of authority here, the model rules and the USPTO code, which of course would apply to registered practitioners before the patent office. We are taught that there is a conflict if the matters would put us in a position of direct adversity between 2 clients, or if our work on behalf of one would be materially limited by our representation of the other client. There is a conflict under the USPTO code, which is originally modeled after the old model code that until recently was the basis for the ethics rules in New York. And so the USPTO is one of those quote-unquote jurisdictions that still clings to the model code formulations, although as registered practitioners well know, the USPTO has put its own spin on these ethics rules. But in any event, the USPTO code with regard to what constitutes a conflict of interest says that there is a conflict if a lawyer's professional judgment would be adversely affected, or if the representations would involve the lawyer in representing differing interests. Conflicts are consentable, potentially, under both regimes. Under the model rules, we have a consentable conflict if the lawyer reasonably believes that she can provide competent and diligent representation to each client. And similarly, under the USPTO code, if it is obvious to the lawyer that she can adequately represent the interests of each, we are in the land of a consentable conflict. Further guidance is provided regarding consentability in, for example, the comments to the model rules. We are told that we likely have a consentable conflict where the clients, although arguably in conflict, are generally aligned in interest. And even though there is some difference of interest among them, there is still the possibility of a consentable conflict. For example, one example that's provided is the example of a willing buyer and a willing seller. On the other hand, conflicts are non-consentable where the clients are fundamentally antagonistic to each other, and an example would be, of course, a settlement of a patent litigation. So, looking back at the question for question 1, a lawyer may not represent both the licensor and the licensee in a licensing transaction. We can say that that is generally true, but there may be situations where the conflict is consentable, and if so, so that's step 1 of the analysis, if there's a consentable conflict. Step 2 would be to inform the parties involved, provide them with informed consent, as we'll discuss, and get their informed consent, and in most jurisdictions, that's going to require a writing on behalf of the client providing consent. What is informed consent? Well, informed consent under the model rules is defined, as are many of the terms, by the way, that I'll refer to. So it's important when reading any ethics code to consult the definitions that are provided. But informed consent under the model rules is defined as the agreement by a person to a proposed course of conduct after the lawyer has communicated adequate information and explanation about the material risks of and reasonably available alternatives to the proposed course of conduct. And I'm going to emphasize in this definition the importance, it seems, under the ethics rules of reasonably available alternatives and the client's understanding and access to information about those alternatives, as we will see. Special considerations in common representation is additional guidance provided by the commentary in the ABA model rules. The comments tell us that A common representation, for example, of a licensor and a licensee in a given transaction would be plainly impossible where contentious litigation or negotiations are imminent or contemplated. Furthermore, common representation would be improper when it is unlikely that the lawyer can maintain his or her impartiality, for example, where one party is a long-standing client and the other one a new one. Another consideration. If the common representation that is contemplated were to fail, ordinarily the lawyer will be forced to withdraw from representing all. And we are exhorted that we must advise our clients regarding the lack of privilege as between them. They will not be able to claim attorney-client privilege as to communications that are involved in this negotiation. So, in fact, the lawyer is affirmatively required to, or exhorted under the model rules, to advise each that material information, in fact, will be shared among them. So the clients are giving up some of what they would otherwise enjoy in terms of confidentiality under these circumstances, and they should be so advised. Now, there are, again, a lot of debates around the proper interpretation and application of ethics rules generally, but particularly I have discovered in the context of negotiations. And this is an example of one commentator who has taken the position that it's just simply impossible to represent both the licensee and the licensor on an ethical basis. This commentator asked, for example, how can the same lawyer ask himself for a copyright infringement indemnification when representing the licensee and deny or limit it when representing the licensor? Similarly, how can the same lawyer ask himself for audit rights on behalf of a licensor and tell himself they are not necessary on behalf of the licensee? So again, there are, with regard to many of the questions that we'll talk about, there are a range of views among experts, but I'm trying to provide you with some sense of the debate so that you can consider the opposing viewpoints, and obviously professional ethics, certainly, although governed by rules and standards and case law and bar opinions and things like that. Some of what has to govern us in the first instance is our own comfort level with these ethical principles. Okay, so an example that the model rules give of a situation where consent would clearly be required is where a lawyer is asked to represent a licensor in negotiations with a licensee that the lawyer or his firm represents, even in an unrelated matter. Under Model Rule 1.7, Comment 7, the interpretation of this situation is that these clients are directly adverse, even though these representations are being carried out in unrelated matters, and that the consent of each would be necessary. Another example that's specifically discussed and maybe of particular interest to this audience in the commentary to the relevant Model Rule 1.7, is this one, which concerns joint ventures. And the commentary here actually goes on at some length. I just excerpted what I thought was the heart of the commentary. A lawyer asked to represent several individuals seeking to form a joint venture is likely to be materially limited in the lawyer's ability to recommend or advocate all possible positions that each might take because of the lawyer's duty of loyalty to the others. The conflict, in effect, forecloses alternatives that would otherwise be available to the client. This notion of the importance of being able to fully advise clients of all of the alternatives that are available to them is a concern that runs through the commentary to the model rules in this regard. In fact, the comment points out that the critical questions are the concern that a likelihood that a difference in interests will eventuate, even if one doesn't exist now, and if so, will that difference in interest materially interfere with the lawyer's independent judgment in considering alternatives? Moving on to question 2. Let's consider an in-house lawyer, although this could certainly, question would apply to outside counsel as well. But I just phrased it in terms of an in-house lawyer. This gentleman wears both business and legal hats for the corporation, as do many in-house lawyers. And so let's assume that this lawyer has decided to negotiate directly with an unrepresented party. What does that lawyer have to take into account? Must she inform the other party that she is a lawyer? Avoid creating the impression that she is not a lawyer? Help the other party to understand the applicable law? Advise the other party to obtain counsel? Which, if any of these, is that lawyer required to do? So again, the analysis, Model Rule 4.3 is the relevant rule that deals with negotiating with unrepresented parties. The Model Rule says that the lawyer must not state or imply that she is disinterested. Furthermore, if that lawyer knows or reasonably should know that the unrepresented party misunderstands the lawyer's role, the lawyer shall make reasonable efforts to correct the misunderstanding. Furthermore, the lawyer must not advise the unrepresented party, except the lawyer has the option of suggesting that the unrepresented party retain counsel. So, back to the question, an in-house lawyer who wears both business and legal hats for the corporation and who negotiates with an unrepresented party must avoid creating the impression that she is not a lawyer. Model Rule 4.3, this is quoting from the comment 2 to Model Rule 4.3, it does not prohibit a lawyer from negotiating the terms of a transaction or settling a dispute with an unrepresented person, so long as the lawyer has explained that the lawyer represents an adverse party and is not representing the person. The lawyer may inform the person of the terms on which the lawyer's client will enter into an agreement or settle a matter, prepare documents that require the person's signature, and explain the lawyer's own view of the document or the lawyer's view of the underlying legal obligations. But as we will see, the further down that list the lawyer moves, the more potential danger the lawyer is involving himself in. For this reason, under question 3, a lawyer who represents a client in license negotiations with an unrepresented party risks establishing an attorney-client relationship with that party. Is that true or false? The answer is true. And the reason is that we always have to be mindful of the fact that attorney-client relationships can be established even where, based on the circumstances. And in other words, it's not a requirement that there be a formal declaration of engagement between a lawyer and a potential client to establish an attorney-client relationship. The test, this circumstantial test, is did the unrepresented party reasonably believe that the lawyer was acting on his behalf? And so when dealing with unrepresented parties, it is important that the lawyer exercise care to avoid explaining provisions or certainly selling the deal. When in such circumstances, the lawyer, of course, risks creating a reasonable impression in the mind of the unrepresented party that the lawyer was looking out for that party as well. And so it may be necessary in order to dispel that impression to affirmatively inform the unrepresented party that you do not represent him. Certainly that would be necessary once the lawyer reasonably begins to perceive that the unrepresented party is in fact getting the impression that the lawyer is acting on his or her behalf, as well as the person that the lawyer has indicated is the lawyer's client. But even short of those kinds of circumstantial indications, it may be wise for the lawyer who is talking to an unrepresented party to inform the unrepresented party that the lawyer is not acting as that person's attorney. Okay, I think this is a good place, before we move on to question 4, to provide you with the first of our 2 CLE authentication codes. This code is a 9-digit number, like a phone number. Well, I guess 9-digit phone numbers are 10 digits, so this is a 9-digit number. The number is, and I'll read it twice, 710-819-911. Again, that first code for CLE authentication, for those of you who have registered for CLE for this program, 710-819-911. And stay tuned for the second code. Okay, question 4 is an interesting question. It is certainly a controversial subject, as I have experienced firsthand, not thankfully to any involvement in the ethics or grievance situation, but as a commentator on this issue, as I'll explain. The question concerns the lawyer who is representing a client in a negotiation, and that lawyer's ability to legally or ethically, under the ethics rules, affirmatively misrepresent the client's bottom line. And I think this is not only a controversial question, it's one that, is a realistic situation. Some of us might likely go through our whole lives not even considering representing both a licensor and a licensee, but it's a common situation in negotiations to be talking about or giving indications to the other side about what the client's bottom line is. So, okay, so is that true or false? Well, let's go through the analysis together. First of all, the relevant rule is Model Rule 4.1. Model Rule 4.1, the actual text of the rule, says that a lawyer shall not knowingly make a false statement of material fact or law to a third person. We are prohibited by the text of the rule itself from knowingly making a false statement of material fact or law to a third person. However, comment 2 to the model rule gives us a definition of fact in this context and says, quote, under generally accepted conventions in negotiations, some statements ordinarily are not taken as, quote, statements of material fact. And the comment specifically identifies 2 examples. One is estimates of price or value placed on the transaction, and another example is the parties' intentions as to an acceptable settlement. So we start there, and we can say that at least ordinarily then, and of course to the extent that Model Rule 4.1 applies in the jurisdiction in question, a lawyer is free to misrepresent the client's number. That's what the preliminary analysis would suggest. Several justifications for this rule have been offered. For example, this bottom line can be interpreted not as a statement of material fact, but rather a statement of the client's intention. So it's out of the realm of fact altogether. Another justification is that the client's bottom line is kind of a moving target. It's based on her belief about what the other party will take or pay, and therefore is not a set in stone fact at the time that the client enters the negotiations. In many cases, as the client gets more information, the client's bottom line might change. So it's different from certain sort of immutable facts that are certainly not going to change over the course of the negotiation. Some commentators have argued that a strict requirement for honesty in this context would simply be unworkable, and therefore that it's not a reasonable interpretation of the ethics rules. So, back to this sort of preliminary analysis, a lawyer representing a client in a negotiation may affirmatively represent the client's bottom line. Under the above described circumstances, I would answer true. However, I have to acknowledge that not everyone agrees. Here's an example of a differing commentary. The lawyer's only option is to negotiate without revealing this fact, and to the extent the bottom line is requested, the lawyer must simply state that this information is confidential and will not be revealed. This is one commentator's view of this fact. I said that I had some personal experience in an earlier version of this paper that I prepared back in the early the early part of the 2010 decade or the 2000 decade. I explained basically the position that I've described, and the article appeared in what was then the ABA's IPL newsletter. It's now the magazine that we know as Landslide. And probably the only time in my professional career there was actually a letter to the editor written back that took significant disagreement and difference with my point of view. That letter writer wrote that while it may be strategic to withhold what one's client is willing to pay or accept, or the client's bottom line as client confidence, this does not justify lying or misrepresentation concerning this fact. And again, continued here, as I've said, the lawyer's only choice is to negotiate without revealing it. And this commentator actually felt so strongly about this that took the position that my position was unconscionable, and in fact that what I had suggested was scandalous. But I'm not alone in my view that this is the proper interpretation of Model Rule 4.1. And I'll mention that I have a paper that that the folks here at the center are happy to share with you and will share with you so that you can dig into this more deeply if you're interested. But I will acknowledge that the model rules send mixed messages on this point. I mean, there are other rules and other commentary that I think it's fair to take into account here. The text of Model Rule 8.4c, for example, says that it is professional misconduct to engage in conduct involving dishonesty, fraud, deceit, or misrepresentation. Again, that's the text of the rule. So you have, in fact, the text of both rules, Model Rule 4.1, which says we may not dissemble about a material fact, and Model Rule 8.4, which says it's professional misconduct to engage in dishonesty, are certainly point away from the interpretation that I've articulated here. Furthermore, comment 1, which happens to be the comment that immediately precedes comment 2 to Model Rule 4.1, says that a lawyer is required to be truthful when dealing with others on a client's behalf. However, Model Rule 4.1 comment 2, which is the source of the authority that I read above to you, is the most on point with regard to specifically the question about the client's bottom line. Another commentator here has indicated that he believes that the same rationale would apply not just to statements regarding our client's bottom line, but statements regarding the limits of our settlement authority. He says that the same rationale applies, and that further adds, if the rule required an honest response to questions about the limits of our settlement authority, the lawyer who disregards that rule would enjoy a significant advantage over the one who observes it. I'd note in this regard that a lot of the analysis regarding this subject and the application of the ethics rules to negotiation settings in general makes the point that much of what goes on in the negotiation context goes on in private. And so one of the things that makes ethics in negotiations challenging is that even what are egregious ethical violations may not go reported, may not go discovered by the authorities. And so it's a different context than, for example, things that happen in open court. I'm certainly not advocating unethical conduct because it's going on behind closed doors. I'm just pointing out that that is important to keep in mind when we take a look at what this commentator is saying. He's saying that, you know, in a private negotiation, the lawyer who disregards a absolute outright prohibition on so-called lying about even things that are statements of the client's intention would enjoy a significant advantage over one who observes, and that the fact that negotiations go on, many negotiations go on in private, just added a dimension to this. Furthermore, this commentator has pointed out that clients would, in such a regime where lawyers could not misrepresent settlement authority, would withhold that authority, and that would add a layer of inefficiency, an additional layer of inefficiency to the negotiation context. Now, it's very important to note that the ABA has an entirely different rule for situations, for statements, including statements about things like bottom line and the limits of settlement authority, that are made to judicial officers mediating settlement. So the ABA views this as an entirely different realm. In other words, a judicial mediation is a different setting from a private negotiation. And the applicable rule is Model Rule 3.3A1, which states that a lawyer shall not knowingly make a false statement of fact or law to a tribunal. Okay, shifting gears a little bit, let's change the nature of the information that the lawyer is contemplating misrepresenting in negotiation. In this question, a lawyer representing a licensor in a negotiation may misrepresent the size of an offer it has received from another potential licensee. Is that true or is that false? This is a different situation because the size of an offer that a licensor has, as a matter of fact, received from another potential licensee, is a statement of fact. And there's no authority that I've come across in the model rules, the commentary to the model rules, or the commentary of experts that would support, as an ethical act, misrepresenting such a fact. Here's another question in the IP negotiation context. Suppose that it is a patent license negotiation May the lawyer for a patent licensor, or must the lawyer for a patent licensor inform the potential licensee of all of the potentially invalidating prior art of which it is aware? Is that true or false? Walking through the analysis, we're now talking about disclosures in negotiation. What kind of information, and what do the ethics rules say about the information that we disclose in the context of negotiations? Again, the applicable rule is Model Rule 4.1, which says that a lawyer shall not knowingly fail to disclose a material fact when disclosure is necessary to avoid assisting a criminal or fraudulent act by a client. However, Model Rule 4.1, Comment 1, adds a gloss on this, that generally there is no affirmative duty to inform an opposing party of relevant facts. And so, taking these together, we can see that the issue concerns that the context matters with regard to disclosures in negotiation, and specifically the relevant fact is, the first relevant fact is whether or not the lawyer is volunteering the information or is responding to an inquiry for information. While I'm on this slide, since we're talking on this slide and many others about both the text of a model rule and the text of a comment, I certainly want to acknowledge that the two don't stand on the same footing. Comments are not rules, and rules are not comments. And I would just point out that, it is important to read them differently. That one has an elevated authoritative status, that, in other words, the text of the rule, that the comment does not have. And much of the analysis that you'll read with regard to the interpretation of ethics rules in negotiations, context, and otherwise, point out that difference. In fact, some of the commentators who, with regard to the topic we were on, with regard to misrepresenting the client's bottom line, will disregard comment 2 to Model Rule 4.1, which was the comment that I based my analysis on the ground that the text of a comment simply cannot vary as an interpretive matter the text of a rule. I just want to make sure that when we're reading the ethics rules, we are keeping an eye on what we're reading, whether we're reading a rule or a comment. But that said, the comments are obviously there to provide interpretive guidance. So, back to question 6. A lawyer for a patent licensor must inform the potential licensee of all potentially invalidating prior art of which it is aware. Relying on the authorities that I've just highlighted, I think a fair conclusion is that the answer is no, unless the other side has asked for that information. In other words, the ethics rules put the onus on the party that is relying on that information to ask for it, but there's a big caveat. That's the answer we get just applying the ethics rules. There may be, in the particular setting, some other factor, some other governing law, for example, securities regulations or some other kind of law, including private law, the law of contract. There may be some prior contractual relationship between these parties that governs the disclosures that they have to make with one another in carrying out additional contractual relationships. There may even be some overarching fiduciary duty that governs in the situation, some implied or expressed fiduciary obligation between the two parties that would require volunteering of particular information. My answer simply says that based on the ethics rule alone and not taking into account any other applicable law or relationships, a lawyer for a license for a party in a negotiation is not required to volunteer potentially material information. What is prohibited, however, clearly, is any kind of misrepresentation by partial truths or misleading omissions. The commentary to the model rule in question, Model Rule 4.1, makes very clear that lawyers can, by their conduct, including can create obligations to provide information where obligations would not otherwise exist. For example, a lawyer begins to disclose some information, but has disclosed what is in fact a partial truth, and thereby creates a misleading impression. It is also the case that, again, private negotiations stand on different footing in this regard from conduct before tribunals. And certainly, as we all know, we are under obligations by the ethics rules as well as by, for example, the federal or state versions of model rules of civil procedure. We are under obligations to disclose adverse controlling law to tribunals. We are also under an obligation to correct any false statements of material fact or law that were previously made to tribunals. So it is important to keep in mind the difference between the private setting and the tribunal setting. Okay, so what about question 7? A lawyer for a licensee who learns during negotiations that his client has understated its past sales of infringing products. What does that lawyer have to do? This is a real hornet's nest, this situation. And as we will see, a big part of the problem here is that with regard to all of the rules that I'm talking about today, this one may be the one where the ethics rules of the various states differ the most significantly. So let's walk through some possible alternatives here. Suppose the client instructs you that you may not reveal the correct figure. So you are an injunction of silence from your client, and the client wants to let sleeping dogs lie and let the other side continue with its misunderstanding created by the client of the relevant sales figures. Do you have an affirmative obligation as a lawyer to alert the other party regarding the understatement, regardless of your client's instructions in this regard? Do you have an obligation to advise your client to correct the other party's misunderstanding and to, in fact, provide the other party with the correct figures? What about any obligation to actually withdraw from the representation if the client refuses to correct the record? And I've got a sort of typical law school or bar exam answer here, answer C, and if necessary, answer D and answer B. So let's just kind of peel back the layers of the onion here because we've got a lot of different potential circumstances, and let's just take the first two. Suppose that the client has, in fact, given you instructions not to reveal the client's figures, or even if the client hasn't, do you have an obligation to alert the other party regarding the understatement? So this deals with setting aside the issues of withdrawal for a moment, just issues regarding client confidentiality. So the ethics law regarding disclosures in negotiations looks like this. Model Rule 4.1, as we've said, says that a lawyer shall not knowingly fail to disclose a material fact when disclosure is necessary to avoid assisting a criminal or fraudulent act by a client. So that's one model rule. However, of course, we have our confidentiality obligations to our clients, and in fact, Model Rule 4.1 on its face makes very clear that acknowledges our confidentiality obligations, and we learn from the rules that we may not reveal client confidences without consent. So there's an inherent tension, in other words, in the context that I've described between Model Rule 4.1 and Model Rule 1.6, at least as far as it goes. However, there are some confidentiality duty exceptions in Model Rule 1.6, and this I think I want to focus some time on because these are somewhat recent. There was a significant revision to Model Rule 1.6 in August 2003, and Model Rule 1.6 was amended to provide additional exceptions to what previously existed. I think many of you will be familiar with the old exception regarding the lawyer's ability to speak up to prevent the risk of death or substantial bodily harm to someone, but these additional exceptions that relate to crimes or frauds that are reasonably certain to result in substantial injury to financial interests are a new development in the land of the model rules. So under this revision, the model rules were revised to provide that a lawyer is permitted to reveal information relating to the representation of a client to the extent necessary the lawyer reasonably believes necessary to prevent the client from committing a crime or fraud that is reasonably certain to result in substantial injury to the financial interests or property of another if the client has used or is using the lawyer's services to further that crime or fraud. So it is important to note, first of all, that even where the ABA model rule 1.6 permits disclosure to prevent client frauds or crimes that are reasonably likely to substantially injure the financial interests of another. The permission is only to the extent that the client has used or is using the lawyer's services to further that crime or fraud. But not every state has adopted those exceptions. And in fact, the correct answer to as between choice A or choice B really does depend, as I say here on this slide, on the applicable confidentiality exceptions. Those exceptions vary significantly. First of all, some states have not adopted the changes that the ABA made in August of 2003. So in some states, a lawyer may not reveal client confidences to prevent a client from committing either a crime or a fraud to financial interests. In other words, in some states, the exception, the only relevant exception, or the only exception of this kind would be to prevent the risk of substantial bodily injury or death to another human being. So that's one possibility. Some states, as I say, well, actually, we'll come back and talk about this. Some states limit the situations to situations where a crime will be committed, but don't allow any kind of disclosure to prevent a non-criminal fraud, a civil fraud. And in fact, New York, the New York Rules of Professional Conduct that took effect on April 1st of 2009, the relevant rule, again, is Rule 1.6, and the exception here says that the lawyer may reveal or use confidential information to the extent that the lawyer reasonably believes necessary, 1, to prevent reasonably certain death or substantial bodily harm, and 2, simply says to prevent the client from committing a crime. So in New York, presumably a criminal fraud would constitute a crime. New York doesn't say anything about the concern about substantial financial interest. This is another difference among the states. The issue to whether any harm or any crime is enough, or whether there has to be, as in the case of the model rule, a crime or fraud that will result in a substantial financial injury. So there's that difference. So the point is the ethics rules in this regard are all over the map, and it is really essential to check the applicable confidentiality exceptions. Now, what isn't so foggy, and what is the subject of a greater level of agreement among the states, is that the lawyer certainly should advise the client to correct the misstatement. So in an ideal situation, obviously the client wouldn't be attempting to perpetrate a fraud by insisting on not wanting to correct understated past sales of infringing products. But even to the extent a client would attempt this, the lawyer is encouraged to try to talk the client out of it. And hopefully the client would correct the misstatement. The client in this regard could profitably perhaps be reminded that aside from any concerns that the lawyer has regarding the lawyer's own ethical obligations, such misrepresentations could subject the client to liability, potential liability for a civil fraud cause of action, or even a criminal prosecution. And so the lawyer has some and there are many cases in which clients and or their lawyers have been, totally aside from any kind of an ethical issue, have been sued for civil fraud in the context of knowing misstatements in the negotiation context. So hopefully the client, advised by the lawyer, would turn back and all would be well. But suppose the client doesn't do this. What about withdrawal from the representation if the client refuses to correct the record? The relevant guidance under the model rules is that a lawyer shall withdraw if the lawyer will violate the law or the ethics rules, and alternatively may withdraw if the client persists in a course of action involving the lawyer's services that the lawyer reasonably believes is fraudulent. So there certainly is a way out for the lawyer. The lawyer can withdraw from the representation. Now, the lawyer having withdrawn from the representation, though, may not be enough to save the victim of the client's attempted fraud here. And so what about the possibility of the lawyer making some noise on the way out? What can the lawyer do in order to protect the victim? of the client's fraud. Well, Model Rule 4.1, Comment 3 notes that sometimes it may be necessary to give notice of the fact of withdrawal and to disaffirm an opinion, document, affirmation, or the like. This is the text of the comment. Furthermore, there was an ABA formal opinion issued in 1992 that said that a lawyer is permitted to disavow a work product used by the client to carry out deception, but only where necessary to prevent the client's use to commit fraud. So once again, there is this authorization for the lawyer, at least when the fraud has yet to be consummated. We'll talk in a moment about situations where the deal has already closed. But during the period of time where the deal is pending, the lawyer is aware that the client has understated material information or has misrepresented material information, that a fraud is going to result. The lawyer has the ability to disavow the lawyer's work product. And that's all the lawyer can do, by the way. The lawyer can't say more, because to say more would be to reveal client confidences, but the lawyer is permitted to disavow to the other side the lawyer's work product. And presumably that level of noise being made by the lawyer would alert or potentially anyway, would alert the other side to the situation and cause the other side to start asking some questions or perhaps call off the deal. So I guess just to recap on this subject, which again is a somewhat controversial and challenging subject, the first question that the lawyer has to ask in this context is, what are my confidentiality obligations? And do I have the authority under the ethics rules to disclose client confidences, which in New York, as you know, information relating to the representation, to disclose a client confidence under the circumstances. And depending on the jurisdiction, the lawyer is going to have to consider whether or not we're potentially in the land of crime, the land of civil fraud, the extent to which financial harm might result, in jurisdictions limiting this permission to situations where substantial financial harm might result, whether or not this constitutes substantial harm. And so it may be the case that the lawyer is permitted to disclose client confidences in order to prevent this kind of financial fraud or crime. Again, ideally, the lawyer will be able to dissuade the client from carrying out this course of conduct. If the lawyer is unable to do so, the lawyer certainly may withdraw, in some cases must withdraw, and then the only thing left is how much noise, if any, is the lawyer allowed to make. The answer is, if the lawyer is allowed to make noise on the way out, that noise, and that's going to depend on the lawyer's confidentiality obligations. The lawyer, because obviously ABA Formal Opinion 92-366 was interpreting the ABA model rule. But in any event, the noise is limited to a disavowal of the lawyer's work product. So, going back to question 7, I think the best answer is answer C. You certainly would want to counsel your client to provide the other party with the correct figures. If necessary, you would withdraw, and in many jurisdictions at least, you would have the option of disavowing your work product, and to that extent alerting the other party regarding the understatement. Okay, it's 5 after 1. I'm going to read the second authentication code now, and then we'll continue the program and get to some questions. The second authentication code, again, a 9-digit number. I'll read it twice. 408-503-655. Again, 408-503-655. Okay, some additional considerations on this subject include the following. First of all, the analysis I've just gone through is the same under the rules, regardless of whether the client's understatement was intentional or innocent. That might change, intentionality might change, obviously would change the analysis in terms of potential liability for fraud. But in terms of the lawyer's obligations, if the original understatement was innocent, what we're dealing with now is the client's refusal to change that. Again, the relevant state ethics rules vary significantly, and some have argued that disclosure to prevent fraud is required, not merely permitted. And what's interesting in this regard is this. If you take a look at Rule 4.1b, it imposes a mandatory duty, as Professor John Humbach has pointed out, to disclose when Rule 0.1 permits. And so Rule 4.1 speaks in mandatory language, and it says that a lawyer must make disclosures to prevent crimes or frauds when Rule 1.6 permits. And so he says that he reads, as a result of these changes I've talked about, a, quote, new and wide-ranging duty to warn the other side. I think it's a fair reading of the rules. What's interesting on this point is that the reporter for the commission that made the 2000, or that recommended the 2003 changes, has basically interprets the rule differently. So we have in this regard the text of the rule on the one hand, and we have the viewpoints of the reporter for the commission that made the changes, and they are opposing in this regard. So I guess in some ways this is I guess it's one of those moments where I think it's unfair to practicing lawyers who are trying to meet their ethical obligations when the relevant authorities themselves aren't clear. Question 8, a couple more questions. These will go a little more quickly. A lawyer for a licensee who learns after the transaction has closed that his client has understated its past sales of infringing products may engage in a noisy withdrawal. Is that true or false? The best answer I can give you is a very lawyerly, it depends. Again, it's going to depend on what the applicable confidentiality exceptions are. Certainly withdrawal is permitted even after the deal has closed, but there are varying authorities regarding whether a noisy withdrawal is, when authorized, is authorized only in the pre-closing time frame, and the view being on the part of some authorities that once the deal has closed, it's too late to prevent the harm, and therefore the permission to make the disclosure has gone away. Okay, here's, I think, an interesting one that probably many people in the audience have actually encountered. A lawyer for a licensee who has agreed to pay the prosecution costs for future patents relating to the licensed technology, but who discovers before the license is signed that the licensor's counsel has failed to include this term in the document, must or should do what? So this is a drafting error. The parties have a deal, one side goes off to draft the agreement, and when the draft is circulated, it becomes apparent to the other side that a term has been omitted that was agreed upon in the draft, and what is that? Obviously, if the term is in that party's favor, they can be expected to speak up. But what if the term is in the other party's favor? What are the lawyer's obligations in this regard? Does the lawyer have to remain silent and, in fact, capitalize on the other side's error? Does the lawyer have to consult with his client to seek permission before calling the error to the attention of the other side's counsel? Does the lawyer have instead the obligation to inform the other side's counsel of her admission? Or does the lawyer have the authority to make the disclosure and the encouragement under the rules to make that disclosure? So we're talking again about drafting errors and oversights. Certainly we'd start the analysis by pointing out that the error relates to the representation and therefore is arguably prohibited by Model Rule 1.6. However, there is an interpretive informal opinion from the ABA issued in 1986 that deals with this particular subject and actually says that the lawyer not only may correct the error, but should correct the error. That this disclosure is within the lawyer's implied authority in the context of this representation, and furthermore, that this lawyer need not consult with his client. This was part of the deal that was done. The client has agreed to this term, and the lawyer therefore has the implied authority to take steps to effectuate the client's intent in this regard. And in fact, the lawyer may not advise the client to take advantage of the other side's mistake. So the correct answer here under the ABA rules is that the lawyer should inform the licensor's counsel of the omission and does not need to consult with the client to do so. Okay, here's question 10, the last question. A lawyer who conducts negotiations in a state other than the states in which he or she is licensed engages in the unauthorized practice of law. Is that true or false? This is a question that concerns multi-jurisdictional practice. The analysis is under Model Rule 5.5. And again, New York has now adopted a version of the model rules, and so New York has a Rule 5.5, as we will discuss. Under the model rule version of 5.5, there is authorization under certain circumstances for multi-jurisdictional practice. Specifically, as long as the lawyer's work in the other jurisdiction is, quote, temporary, and obviously reasonable people can disagree about what that means, but that's as definitive as the ABA could be on this. Temporary, although the ABA does tell us that temporary could include work that is on a recurring basis or for an extended period of time, such as when the lawyer is representing the client in a single lengthy negotiation or litigation. That could still qualify as temporary, but there's an additional requirement. The work must either relate to a pending or potential judicial proceeding in which the lawyer is or will be authorized to practice, or is otherwise related to the lawyer's practice in his home state. Under those circumstances, as relevant to the problem that I've drafted, this work is authorized. So, it is probably false in most jurisdictions that a lawyer who conducts negotiations in a state other than the states in which he or she is licensed, it is probably not true that that lawyer is engaging in the unauthorized practice of law. But in New York has not adopted. It adopted portions of ABA Model Rule 5.5, but did not adopt this temporary and related to authorized practice exceptions. It's, and here again, the states differ, and it's clear in some states that states have made a conscious choice not to adopt this rule. It's clear in other states that this is kind of a work in progress, so we'll have to see how things develop. I'm just calling to your attention, this is one significant difference between the New York version of Rule 5.5 and the model rule version of 5.5, and it simply is the case that the New York rules do not address multi-jurisdictional practice. So, I note here that it is very clear, comes out of the ABA's work in this regard, that a lawyer is subject to the disciplinary authority of any jurisdiction in which she practices. So, whether or not she is authorized under the rule to practice in a jurisdiction, she is subject to the disciplinary authority of that jurisdiction. Furthermore, there is this highly controversial California case relating to the possibility of fee forfeiture. An out-of-state lawyer who negotiates on behalf of a client in California, it should be noted, may also risk fee forfeiture. This is the notorious Bierbauer case from 1998. There has been some additional law in California in this regard. Subsequently, the court held that if the out-of-state lawyer's client is not a California resident, the Bierbauer case doesn't apply. There isn't a Bierbauer analog in most, if any, other jurisdiction, but I would just note that California has this additional wrinkle. I just would close with these observations. Obviously, negotiation is a fundamental part of lawyering, whether that negotiation is informal or formal. The ethics rules, I think it is fair to say, set limits, provide guidance, but they also recognize realities in negotiation and indeed promotes zealous advocacy. So with that, I will stop talking and see what questions or comments you have.
Lisa, perhaps you could address, is there an example of a licensee-licensor situation that you think is worth the risk of proceeding that's fairly typical in intellectual property practice?
Yes, the question was, can I think of an example of a common representation situation of a licensor and a licensee in the same transaction that would be acceptable in the intellectual property context. An example that I note in the paper, and I'm a fairly conservative person in this regard, so I would certainly not want to come across as encouraging this kind of representation. But I think it is certainly the case that, I think the example I use in the paper is perhaps a trademark license between a trademark owner and a holding company. I mean, obviously they're, in that sense, the same party. And you can, so therefore you can see how unwilling I am to go out on many limbs in this regard. I would encourage you, though, in this context, and this reminds me of something I would have said earlier had I thought about it, There are there's particular guidance in the ethics rules and commentary relating to the treatment of corporate affiliates and the extent to which they are considered to be the same party or not for conflicts purposes. And I would encourage you to, if you're ever involved in a case involving affiliates in the conflicts context, whether it's in the litigation context or the negotiation context, to consult that authority. It's quite helpful. And again, there are important differences between the states in this regard. And another very important thing that I would offer to you that I have found extremely valuable in my research is that on the ABA website, the ABA has created numerous compilations of the differences between the various states' versions of some of the key ethics rules. And I have some of those sitting here so I can give you some examples. For example, the ABA has a compilation relating to variations of the ABA Model Rule 1.16 relating to declining or terminating representation, Rule 1.2 relating to the scope of representation between client and lawyer, this all-important Rule 1.6 relating to the confidentiality of information, and again, the states are all over the map on that one. In fact, there is a textual and a tabular comparison of the state confidentiality rules. Rule 1.7 relating to conflicts. Rule 1.7 comment 34 is the relevant guidance on affiliates, client affiliates in the conflicts context. There's a comparison of the state's version of Rule 1.9, which deals with former client conflicts, and there's a nice thick compilation relating to Model Rule 1.10, which we didn't talk about at all in the context of this presentation. It relates to the imputation of conflicts of interest inside law firms and other multi-lawyer organizations, and it was significantly revised by the ABA in 2009. Again, the states are all over the map on that, so these compilations are terrific on the ABA website for being able to compare and get quickly into the potential wrinkles among the ethics rules in a particular state that you're in. Again, there are comparison of Model Rule 4.1 that I talked a lot about today and Model Rule 5.5 relating to the unauthorized practice of law, and in some states, but not New York, multi-jurisdictional practice. So I cannot recommend those highly enough to you. They're great resources.
Unless you want, no one has typed any questions further.
I can see a couple of questions. I see one from Professor Hagelin. Is there a means to obtain an advisory opinion on some of the more difficult questions? My understanding is that there is, and this isn't something that I'm an expert on certainly, but my understanding just from hanging around ethics issues is that there is often a way to obtain some sort of an advisory opinion. There are at least phone lines that you can call in certain states to request ethical guidance, and there is ample room under the ethics rules to disclose facts to ethics authorities for purposes of getting this kind of advice. So again, I'm not an expert on this. I haven't ever done it on my own behalf, but I would encourage you to investigate in a given situation the possibility of obtaining some kind of advice, because I would be willing to bet that there is help available. And I'm just looking to see if I can see any more questions. I see lots of concerns about the sound. I know that we have those, and again, we are so sorry. This did not certainly come off the way we had hoped that it would. Okay, so if there are no further questions, I guess we can conclude. This is, I think, an interesting subject. I would just invite any comments that you have for me as I continue to work on some writing in this area. If you have a particular hypos that you think would be interesting for me to analyze under the rules and perhaps add to my paper, I would love to consider those. I'm always thrilled to hear from all of my friends here at the center. And again, thank you for participating in today's program.